Welcome to Cherry Bekaert's podcast on 179D deduction for A&E firms. I'm Scott Duda, leader of the professional services industry, and with me is Ron Wainwright, strategic tax partner, who's going to discuss the impact of this recently signed Inflation Reduction Act and the 179D deduction coming out of that. Welcome, Ron.
Thank you, Scott. It's good to be here today and look forward to discussing with our listeners the hot topic for A&E firms, as you've highlighted in 179 Cap D.
Yeah, so Ron, can you give us sort of just an overview of the Inflation Reduction Act and its impact there? What's in that and what's coming out of it, and what do we see?
Very good. Well, I think I would say all of our listeners are probably fully aware of the passage of what is referred to as IRA of 2022. IRA stands for the Inflation Reduction Act of 2022. The Senate passed it on August 7th across straight party lines of 51 to 50. The House then subsequently passed it on August 12th, and then President Biden signed it into law on August 16th. In essence, the bill reinstates and significantly expands a number of incentives by providing approximately $370 billion of new energy-related tax credits over the next 10 years. It is expected this legislation will have a significant impact for companies and specifically for A&E firms relying on a number of the funding mechanisms as well as the credits and incentives in IRA of 2022. Taken as a whole, these incentives are significant with respect to traditional companies. It is expected to be a wide range of businesses, B2B and then B2C companies. And of course, A&E firms being kind of the backbone of construction and design work throughout the country. There are a number of provisions that are very specific, which we'll discuss today.
Yeah, so Ron, with respect to A&E firms, can you highlight some of those areas specifically around the architecture and design work that they're doing and how that may lead to this credit?
So sure. So one of the unique features of the IRA is that it permits taxpayers in particular situations to ultimately take advantage of what are called bonus credits, which we'll talk about today. And really, when you think about the bonus credit, as we'll talk about, it deals with what's referred to often as prevailing wage and apprenticeship programs and domestic content. There is new energy communities. There's also some provisions for low-income communities. And then there are some key concepts insofar as how to monetize the credit. And there's what is referred to as a direct pay credit, where a taxpayer could ultimately elect to, instead of monetizing a credit into its tax liability, reducing the tax liability, ultimately make an election for a direct payment of that tax credit in a refundable manner. So when we think about A&E firms, I would say that there are four areas that A&E firms are going to be significantly impacted by. First of all, there is a non-business energy, what's referred to as a property credit. And so as A&E firms are designing, I will say, non-business type buildings, you're going to be asked underneath IRA to really focus in on those areas that your client can ultimately, either in a direct pay format or in a credit format, take advantage of the non-business energy property credits. And when you think about that, it really deals with energy property with respect to water heaters and heat pumps and central air conditioners and hot water boilers, oil furnaces, air sealing, really a number of areas in what would be deemed to be the non-business energy area. When you think about kind of residential clean energy, there's also a provision that was placed in the statute which allows taxpayers to claim credit for qualified residential energy property. And so in the design, you're going to see your clients ask you to design very specifically towards these, quote, residential clean energy credits. And then clearly a third area, which we will talk about today, is the energy efficient commercial building deduction, as well as the new energy efficient home credit.
So can you talk a little bit about that? So I understand within IRA, there's fairly substantial changes, especially to that 179D deduction that we've talked about previously. So can you give us, our A&E firms, a little bit more detail there?
Absolutely. So most of our listeners are hopefully familiar with what is referred to as the energy efficiency deduction, or 179 Cap D, which came into the tax law in 2005 underneath what was referred to as the Energy Policy Act of 2005. And in that act, it gave a additional deduction, i.e. 179D, attributable to designers of energy efficiency systems. So what IRA does is it expands substantially the 179 Cap D deduction. Really beginning in 2023, IRA modifies and expands and extends the energy efficiency commercial building deduction. So our listeners may be familiar with the prior law. Again, this takes hold in January 1 of 23. But previously, to the extent an A&E firm was designing a building for specifically a governmental entity at the federal or state or local level, that governmental entity could in fact transfer up to $1.80, but now indexed by inflation on gross square footage, what was referred to as the 179 Cap D energy efficiency deduction, which was basically the gross square footage of a building multiplied by, in 2022, $1.88. And so they were looking at very specific areas of the building around the structure, the mechanicals, as well as lighting. So what does IRA do? It expands and extends the energy efficiency commercial building deduction, but it has two really key areas in there. First of all, the old law tells us that design of the energy efficiency system had to exceed 50% of the ASHRA standard, depending on when that building and when the law was applicable to that building being placed in service. So the Inflation Reduction Act actually reduces that 50% now down to 25%. And it also continues to reference the standard of ASHRA 9.1 2007. So that's pretty impressive when you think about it. Instead of having to design a 50% greater efficiency over 9.1 2007, now it's been dropped to 25%. However, that's not where the good news comes in. The good news comes in is there is a change in that deduction. So now the base deduction will be 50 cents per square foot. And remember, that used to be 60 cents per square foot. But in this case, the deduction can be increased upwards of 2 cents for each percentage point increase in energy efficiency up to $1 a square foot. So you immediately move that, quote, old law of 60 cents to $1 a square foot. And then we get into what are called bonus deductions that ultimately would be $2.50 per square foot base credit, but this time it's multiplied by 5. So that's in the case of what I mentioned was the prevailing wage and apprenticeship requirements that are in IRA. So the takeaway on 179 Cap D is for A&E firms that are designing for governmental entities, federal, state, and local. They could be eligible for a transfer of an energy efficiency deduction up to $5 per square foot. That's not where the good news ultimately ends. The good news now expands that a not-for-profit entity can also now transfer that energy efficiency deduction to our A&E firms. So that expands the ability for architects and engineers. Previously, a tax-exempt entity, a church, et cetera, or a hospital was unfortunately excluded from the statute of being able to transfer that deduction. So again, $5 a square foot. If you meet certain standards, specifically those bonus deductions come in play when you have a what's called a prevailing wage and an apprenticeship requirement, which are standards that we believe are easily met. So you think about $5 per square foot on gross square footage, and then you think about expanding it also on the deduction towards any tax exempt or 501c type organization. So when you think again of churches and hospitals, et cetera, they may now transfer the deduction to the A&E firm. So really a lot of good news in 179 Cap D. What I would mention to our A&E listeners today is that the service, Internal Revenue Service, did issue recently a audit technique guideline that does require very specific areas for the energy efficiency deduction to be certified. And we have an upcoming podcast on that for our listeners.
So they've reduced the energy efficiency hurdle to get the credit. They've increased the value of the credit, the potential value of the credit. They've increased the organizations that this would apply to that could transfer that to you with the not-for-profits as well. But then they've also sort of ratcheted up the looking into that credit to make sure that it's being taken appropriately. Is that sort of a good, is that what I heard you say?
That's a good executive summary, Scott. You've hit each of the four key points. Obviously, the IRA legislation is massive, but those are the four really key takeaways for our listeners today.
Good. And then I understand there's a multi-residential credit in the IRA as well, and maybe some changes to that? Correct.
So underneath the Energy Policy Act 2005, there was what was referred to as a multi-residential credit. And every A&E firm that has designed an apartment complex or really any, multi-residential type complex has probably been asked to draw or design, I should say, to certain ResNet standards. And so with respect to the 45L, as it's referred to, or the energy efficient home credit, it's important to note that this did expire. However, within the Inflation Reduction Act, it was retroactively extended for the next 10 years. So it actually now picks up 2022 all the way through 2032. So basically very similar to 179 Cap D. It increases the value of that residential energy efficiency credit, and it ultimately provides contractors with tax credits for housing units built or remodeled to reach these, quote, energy saving specification for really a variety of home types, which I'll kind of outline at a very high level. There also is what's referred to as a bonus credit, very similar to the bonus credit. It gets the energy efficiency deduction to $5 a square foot. There's also a bonus credit that can be reached at $5,000 per unit, very similar to the 179 Cap D. So when you think about single family homes, sort of A&E firms that may be designing very high-end single-family homes, the energy efficiency standard is what's referred to as the Energy Star. The base credit is $2,500. So again, there's an increase of $500. When you think about manufactured homes, where an A&E firm might be designing on manufactured homes, predominantly by large builders, in this case, the energy efficiency standard is the Energy Star Manufactured Homes program. Again, a base credit of $2,500. And then when you get into multifamily homes, very similar, there's an extra bonus credit of $500 on a base credit, and then upwards of $2,500, quote, per home. And then ultimately we get to what's referred to as the multifamily homes zero energy ready which is what I would expect A&E firms to be asked to begin to really design to, because in that case, the bonus credit is $5,000 per unit. So, you think about a multi-residential complex of maybe, 200 units. You take that 200, multiply it by $5,000, and then that is the amount of quote bonus credit that that quote developer and or the contractor is eligible for. So I think that'll be a very large and significant impact to our listeners and our A&E firms today.
So, Ron, as we think about our clients and those listeners, the A&E firms out there thinking about this, what should they be evaluating related to their ongoing and upcoming A&E designs? They've got these in progress or they've got some upcoming. What are the critical things that they should be thinking about related to those to see whether these deductions would apply to them or the credits would apply to them, and how they can implement those?
Excellent question. And so what we're recommending to our A&E clients, as well as those listeners that hopefully will become Cherry Bekaert A&E clients, is to go ahead and pause in your designs, because the way the statute or the law works is it is effective January 1 of 23. And so what does that mean? It means that any unit, whether that is a commercial building, and or, as we discussed, now a tax-exempt entity, perhaps a church. The key triggering date is the placed in service date. So as you're designing in 2022, it is likely that construction and that placed in service date is going to be, of course, 2023, and or further out, depending upon the size of the project. And so we would tell our A&E firms to go ahead and begin to think now, along with your clients, to take advantage of these increases in 179 Cap D, again, up to $5 a square foot with a lower energy efficiency requirement, as well as in the 45L, where it was 2,000, now potentially 5,000, because the trigger date is that placed in service date, or in the 45L when you rent and or sell that specific unit. So you really need to go ahead and begin to think about in your design, are we already meeting in my design the new or lower standards attributable to 179 Cap D and 45L. So really A&E firms need to understand this statute very specifically. And of course, Cherry Bekaert stands ready to assist you and help you in understanding this new tax law, freshly minted August 16th. In regards to making sure that your clients are fully taking advantage of these energy incentives, credits, deductions in the IRA of 2022.
Thanks, Ron. This is great information. I know we've got a number of important pieces of information coming out related to the Inflation Reduction Act of 22. I think you highlighted a few of them, but can you give our listeners the highlights of those that we've got planned and upcoming?
Correct. Because of the volume and the size of this piece of tax legislation, we have a number of thought leadership positions coming out underneath Scott as our industry leader in our professional services group, as well as specific to our A&E clients. And so we have upcoming podcasts, as I mentioned previously, in regards to, the new audit technique guideline around the energy efficiency deduction, and what does that mean to ensure that as a transfer of in essence, a phantom deduction now at $5 a square foot or gross square footage to you is done correctly, and you're minimizing your tax liability appropriately. So we have that forthcoming along with the thought leadership position. We also have a number of podcasts that coming up in regards to IRA of 2022, specifically, as I mentioned, in the key concepts of the bonus credit. And what exactly does that prevailing wage requirement mean? And how do I ensure my client understands that, as I'm an A&E firm and want them to maximize the benefit of these deductions and credits? Or more importantly, if I'm designing something for the federal, state, or local government, or now a tax-exempt entity, that I am making sure that I receive that full $5 because there are what are called prevailing wage and apprenticeship requirements. And then we also have a podcast coming up on that key concept of credit monetization. So I mentioned direct pay. So in that case, well, what does that mean that a taxpayer can elect for a direct payment of the credit as opposed to monetizing that against their tax liability? Often A&E firms and taxpayers in general like to have the government finally kind of send them a check. So we'll be covering that in an upcoming podcast. So a lot of good news out there for our A&E clients, and specifically in the professional service group industry.
Thanks for that. Sounds like we've got a lot that is in the pipeline. We'll be on the lookout for those pieces. And for our listeners, please let us know how we can continue to be your guide forward related to these various credits and incentives.